be opened. But ask everybody, please stand up and face the American flag, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with a life, liberty, and... Oh. Thank you. Have the clerk read the warrant or the charge?
Town of Ayer Special Town Warrant. Ayer Shirley Regional High School Auditorium, 141 Washington Street, Ayer, Massachusetts, 01432. March 19th, 2018 at 7 p.m. Commonwealth of Massachusetts, Middlesex, SS. Greetings. In the name of the Commonwealth of Massachusetts, you are hereby directed to notify and warn the inhabitants of the town of Ayer qualified to vote in town elections and affairs to meet at the auditorium in the Ayer Shirley Regional High School, located at 141 Washington Street, Ayer, Massachusetts, on Monday, the 19th day of March, 2018, at 7 o'clock in the evening, then and there to act on the following articles. Hereof fail not, and make due return of this warrant, with your doings thereof to the town clerk before the date appointed for said meeting. Given under our hands this 20th day of February, AD 2018, Christopher Hillman, Chair, Janice Livingston, Vice Chair, Gary Luca, Clerk. A true copy attests Susan Copeland, date February 23rd, 2018. As directed in the foregoing warrant, I have this day posted 3 attested copies in 3 public places, one of which was the town hall at least 14 days before said meeting, all as herein directed. Richard Scotchless, February 23rd, 2018.
Before we get started, I just want to introduce people on the stage up here. My name is Tom Horgan. I'm the town moderator. To my right is the Board of Selectmen, or 2 of the 3 of them. You have Jane Livingston and Gary Luca. And to their right is Town Administrator Robert Pompriand. To my left is Susan Copeland. Then to her left is the Planning Board. You have Jeff Tillotson, Ken Diskin, Susan Kennedy. Am I missing somebody? I see 4 people up there. Mark's up there. Oh, Mark. Okay, I'm sorry. And Town Planner Mark Archambault. And we have on the audience on here is our Zoning Enforcement Officer, Charles Schultz, and Community and Economic Development Director, Alan Minoyan. Article 1, proposed revised Ayer zoning bylaw. To see if the town will vote to amend the Ayer zoning bylaw by replacing the text of the zoning bylaw in its entirety with a new text as found in the document labeled Proposed Ayer Zoning Bylaw, dated February 15th, 2018, as available for review on the town website and as on file in the offices of the town clerk and the planning board. And further to amend the zoning map as on file in the offices of the town clerk and the planning board, and to authorize the town clerk, in consultation with the town administrator, to assign appropriate numbering for this bylaw so that it may be in compliance with the numbering format of the town bylaws, or take any action thereon or in relation thereto.
Mr. Moderator?
Ms. Livingston.
I move that the town vote to amend the Ayer zoning bylaw by replacing the text of the zoning bylaw in its entirety with the new text as found in the document labeled Proposed Ayer Zoning Bylaw, dated February 15, 2018, and amend the zoning map as on file in the offices of the town clerk and the planning board, and authorize the town clerk in consultation with the town administrator to assign appropriate numbering for this bylaw so that it may be in compliance with the numbering format of the town bylaws.
Is there a second?
Second.
It's been moved and seconded. The motion is on the floor. The town planner, Mark Archambault, has a short presentation to start before we start debate on the motion. Mr. Archambault?
Employment opportunities in the commercial and industrial zones. Abundant water resources, including 2 great ponds and several impoundments that make Ayer a very water-rich town. We have a rail trail that connects the town of Ayer with Nashua, New Hampshire, which is something that I take advantage of once the weather gets nice. And we have two areas of critical environmental concern, which are unique natural areas which are rich in plant and wildlife. However, despite all of the assets that the town has, there still remain a few challenges facing us in the planning realm. We have underutilized, outdated, and poorly designed commercial areas, sprawling subdivisions that are encroaching on Ayer's last remaining wild areas in the north-central part of town, surface and groundwater contamination resulting from past industrial operations, an outdated zoning bylaw and set of land use regulations, which is why we're here tonight. So the purpose of this first warrant article is to pass an improved baseline zoning bylaw for the town. The new bylaw features simpler language, list of standards instead of whole paragraphs, more tables and charts, and is generally easier to use than the existing zoning bylaw. So where there is a hierarchy in planning that governs how land uses are controlled in a town. And at the top, you have the master plan, which is the overall vision, and it sets the policies of what the town aspires to. And we're fortunate that at the same time that we have been working on the zoning bylaw, the Master Plan Committee has been working on updating the 2004 Master Plan, which could be adopted this spring. The zoning bylaw comes after the master plan, and it helps to implement the vision and policies that are set forth in the master plan by regulating what land uses can occur where and at what level of intensity. Then we have site plan, subdivision, Board of Health, and other regulations that help to translate the zoning bylaw provisions into very specific technical requirements and standards that govern how development can occur in a town. Now, the new zoning bylaw has been in the works for a while. It feels like it's been about 67 million years, though I think it's been not quite as long, but the last week or two it has seemed that way. Ayer adopted its first zoning bylaw in 1973. And in the several decades since then, there have been several updates, with the most recent comprehensive update being in October 2006, which was revised up until 2009 with several minor revisions and reorganization. However, over the years, this present bylaw has proven to be inadequate in terms of consistency, clarity, and organization. A professional planner was hired in 2015 to revisit the bylaw and improve it without making any major changes, which is the subject of the bylaw tonight. Now, the proposed zoning bylaw went through an extensive, has gone through an extensive public outreach and hearing process. The Planning Board held several public hearings, the first on October 5th, 2017, with several continuations, and then again on February 15th, 2018, with one continuation. Town Hall staff, including myself, once I was hired last September, we had a small group that reviewed the proposed bylaw, and we looked at it for minor changes that we made to improve it. And that is why we had the second public hearing in February. And in addition to the legally required public hearings, we also held some informational forums. We had the first public forum on January 24th, with the second one on February 13th. There was a third public forum anticipated for March 7th, which was the first of the 3 blizzards we've had in the month so far, so we had to cancel that. The bylaw will be reviewed by the Massachusetts Attorney General's office after town meeting vote, assuming that it is passed. Now, just as important as what the new zoning bylaw does is what it does not do. For the proposed zoning bylaw, we deliberately decided not to change any existing lot area, frontage, or setback requirements, nor did we change any zoning district boundaries except for the creation of a small mixed-use transitional district along part of Central Avenue, which I will be describing shortly. So if you have an existing single-family home on a 12,000 square foot lot, that won't change. Your frontage will not change. Your setbacks will not change. We deliberately set it up this way so that we could have a better baseline zoning bylaw in which to work from. Now, there are several ongoing benefits to the updated zoning bylaw. I will not read every bullet point in here, but there are three main categories that are applicable. First is improved structure, clarity, and process. Second is improved community character and protection of environmental resources. And the third is encouragement to business and economic development. And I will describe in just a few words what the mixed-use transitional district is. The Central Avenue Mixed-Use District was a recommendation of the 2004 master plan, which is the most recent master plan that has actually been adopted by the town. Mixed-use districts are one way to encourage revitalization of areas and economic development. Some of the key features of the mixed-use district along Central Avenue include the residential uses, which include single-family, duplex, and multifamily, just as they are now, which are found in the general residence zone. Commercial and retail uses, which are allowed in the downtown business zone. And apartments above the ground floor of commercial buildings are also permitted. So what the mixed-use district essentially does is take the best features of a residential zone and a commercial zone and mixes them so as to promote greater economic opportunity as well as housing opportunity. And at the present time, the only area proposed for this is what is shown in light blue up there. Is that the laser pointer? Whoops, nope, I turned it off. Cindy? Okay. Yeah, I thought I had a laser pointer on me, but oh well. Yeah, you can see that teal blue color. I left my laser pointer in the other jacket. So to summarize, how will the new zoning bylaw help improve life in the town of Ayer? First, by its improved organization, the new bylaw provides a greatly improved foundation upon which to build zoning in the future. It provides better standards for commercial development in terms of landscaping, parking, and other non-residential site design features that reflect the current best planning practices in Massachusetts. It supports the vitality of the downtown and commercial zoning districts by improving the standards for development review as well as allowing for additional mixed uses. And it helps the town meet the state's affordable housing requirements by requiring that a certain number of affordable units be provided in larger scale townhouse and multifamily developments, so that 1 out of every 5 new units proposed as a multifamily development must meet the state's definition of affordability. And that will help the town get over its 10% requirement that will be useful in both meeting the housing needs and also giving the town more local control over housing development. If a town lacks that 10%, it is subject to what is known as a comprehensive permit or 40B development, where the town doesn't have much say in how that is developed. So if we can get over that 10% threshold, that really helps us. In my last slide, I know this bylaw is 95 pages, and there's a lot there. But I would state, and I found this quote, "Let not the perfect be the enemy of the good." And when applying the zoning bylaw to real-world developments, it's not uncommon to find little typos or tweaks that, you need to fix. And you often find this when you're actually looking at a site plan or a subdivision plan. We'll keep that in mind. And the plan is, if we do find any such items in need of improvement, we will bring them to a future town meeting, such as the fall special town meeting. Though we have done our utmost to try to minimize any such revisions. So again, in summary, the primary purpose of the new zoning bylaw is to provide a better baseline zoning document that can be added onto as needed and to promote better development in the near term and lead to a better quality of life for years to come. And that is my presentation, Mr. Moderator.
Thank you. The planning board has a report they have news. This is a legal requirement required by the state law.
Mr. Moderator, I'm Jeff Tillotson with the Planning Board.
Hey, Jeff.
The Ayer Planning Board held 2 public hearings on the proposed revised Ayer zoning bylaw. The first public hearing was held on October 5th, 2017. The second public hearing was held on February 15th, 2018. At the conclusion of the public hearing on February 15th, 2018, the Ayer Planning Board voted unanimously to recommend Article 1, Proposed Revised Ayer Zoning Bylaw, to the Ayer Town Meeting for approval. Thank you, Mr. Moderator.
Welcome. Any further discussion on the article? Ms. Bedurtha.
Mr. Moderator, I have a few questions.
Go ahead.
Have we already met our quota for affordable housing at this time?
Through me to you, Mr. Archambault, or
Through the moderator to Ms. Bedurtha's question, sorry. I believe we have not, though the Economic Development Director, if he's here, could mention, but I believe the town is still under the 10% threshold.
Because I think I remember not too long ago, maybe last year, that we've met that. That's why I was asking.
To the best of my recollection, we have not.
Mr. Luca.
Yeah, I believe it's at 8.4% right now, but I don't know if that has changed much. It's right around there.
I'm not a big proponent of mixing things up, and the word streamline from past practices and business, it's a shortcut, and that worries me. So I just wanted to say that.
Yeah, thank you.
Ma'am, could you please state your name?
Bonnie Tillotson, Oak Ridge Drive. I'm totally in favor of the bylaw. I do have one question, though, regarding the mixed-use transitional district along Central Ave.
State your question.
So the question would be, if this goes into effect, will there also be simultaneously road work, sidewalks, and lighting to go along with, new I'm assuming new development along the corridor?
Mr. Archambault?
Mr. Moderator, to Ms. Tillotson's question, not necessarily. The bylaw sets up the framework for mixed-use development, but it doesn't mandate it. The only time that public improvements would be needed is if there's an actual development being proposed. Short of that, nothing may happen. It's possible that nothing may happen for a few years. But if one of the owners of a large building in the mixed-use district does propose to put some incubator space in there or put a cafe in there, it may or may not be needed to improve the water and the sewer and all that. But there are no plans at this time to do so, and it would only become a requirement if such a development were to occur.
Any further discussion? Mr. Tillotson?
Thank you. Again, Jeff Tillotson resident of Oak Ridge Drive. You may have figured out I live with Bonnie. There has been a motion brought forward, an amendment, to amend a definition in the revised.
Make your motion.
Thank you. Section 9.1, and I apologize, this is kind of dry reading, but Section 9.1.5 B.4 on page 62 on access driveways and interior circulation reads, wherever feasible, access drives shall be designed to minimize curb cuts on existing public ways. Subject to approval by the planning board, shared access to 2 or more adjoining parcels may be provided through 1 or more of the following methods. A cul-de-sac or loop road or common driveway shared by adjacent lots or premises. B, joint and cross access between the lot and adjacent uses. C, an existing side or rear street. D, a cul-de-sac or loop road shared by adjacent lots or premises. Shared driveways serving residential lots are allowed and encouraged to reduce pavement and impervious surfaces. Excuse me, I'm sorry, just double checking. We would like to change it to read lot frontage. I'm sorry.
Actually, I think the amendment I have written here is actually just the next paragraph. You're scratching out one line, correct?
Yes, exactly.
Okay.
So this discrepancy can be remedied by striking the second sentence in the definition of lot frontage as seen below. Lot frontage, a lot line coinciding with the sideline of a street which provides both legal rights of vehicular access and physical vehicular access to the lot. Said line to be measured continuously along a single street or along 2 intersecting streets if their angle of intersection is greater than 120 degrees. It's going to strike the next language. Vehicular access to a building on site, to a building site on the lot shall be exclusively through the front of the lot. On a lot with frontage on more than one street, frontage on one street only may be used to satisfy the minimum lot frontage. This was voted on. The Ayer Planning Board approved this amendment by a vote of 2-1 at its March 15th, 2018 regularly scheduled meeting.
Okay, is there a second? It's been moved and seconded to strike out in the second sentence in the paragraph starting lot frontage, striking out the words, vehicle access to a building on the lot shall be exclusively through the frontage on the lot. Is there any discussion? Mr. Horgan.
Mr. Moderator, I'd like to offer a friendly alteration to this amendment.
State your amendment.
Instead of removing the crossed-out section, prior to that crossed-out section, please insert the words, unless otherwise approved by the planning board, comma.
Is there a second? So moved and seconded to, instead of striking out that line, to insert in the end of the line before it, unless approved by the planning board. Unless otherwise approved by the planning board. Write that in writing. So, Kev, can we have it in writing? We got pads up here. Yep. You can only have 2 in them. You only have 2 motions on 2 minutes. Okay. Any discussion on the amendment proposed by Mr. Horgan? Mr. Gardner.
I only had an opportunity to make one of the public hearings. I didn't get a chance to really address this question, but was there any consideration given when the planning board held their public hearings to having the corner lots by the normal definition? Let's say that hypothetically the...
Mr. Gardner?
Yeah.
The question right now is on Mr. Horgan's amendment to insert those words at the end of the line.
Right. I understand that. I thought this was germane to that, frankly.
Oh, okay.
But the moderator rules, whatever you say.
Yeah, okay. If you can bring it tight in quickly.
All right. Well, in other words, to have, when you have a frontage on 2 lots, which maybe both frontages are inadequate by definition, but the total would exceed the required frontage. Was there any discussion on that?
Okay, that's not germane to Mr. Horgan's amendment.
All right,
Okay.
well, then I'll,
When we get back to the main article,
we get
that-
back to the main article,
yeah.
that'll be fine. Thank
That'd be
you, Mr.
appropriate, yeah.
Moderator.
Okay. Any further discussion on the amendment? Please identify yourself.
Linda Garant, Cambridge Street. I'm just curious, since there was a dissenting vote on the planning board, does the friendly amendment address whatever concern the dissenter had?
Is there any, yeah. And by the way, when you're addressing the audience, mind standing up, please? Do you mind standing up? Yeah.
My name is Ken Diskin. I'm the member of the planning board that dissented at the meeting of last Thursday night. And this would satisfy my dissension. I felt before the vote on Thursday night, when this came up at the last minute, that we were uninformed about the fact that this was coming up so late in the discussion, and that it had gone through the hearing process. I feel comfortable with the fact that if it's left up to the discretion of the planning board to discuss this issue on a case-by-case basis, that it does make sense, and I think that's valid.
Thank you.
Mr. Moderator?
Mr. Moore.
Calvin Moore, I'm just questioning a couple things. One is that the way it is written is a conflict in the bylaw, and that's why this provision amendment was made up. And town council, the way I understand it, says it's a conflict. Town planner says it's a conflict. Selectman's office says it's a conflict, and it goes on and goes on. And what I'm starting to hear is wordage to stop one development going on in this town, and I feel that's very self-driven. And if town council or somebody else can address this issue, but this is not right. Conflicts of interest, I'm sorry, the conflict of the amendments that are in the bylaw has to be taken care of. It's going to get thrown out if it doesn't.
Mr. Rich, you have, no? Any further discussion? Mr. Horgan.
I believe by inserting those words that conflict is addressed.
Any further discussion? There being none, and this is on Mr. Horgan's amendment only. Oh, Mr. Moore? Okay.
I guess I'm going to ask should we get town council involved in this because it's a structural flaw in the bylaw? And shouldn't that get addressed first and be taken care of?
Mr.
A lot
Rich?
of these other issues are mute.
Mr. Moderator, through you to the meeting, as has been explained to me, the intent of this amendment, or the original amendment, was to clarify and address the internal conflict within the bylaw. And as I understand it, the further friendly amendment has further clarified so that the recommended language to be deleted is now no longer necessary to be deleted because it places the issue back within the purview of the planning board. So I believe this will address the conflict and will clarify the issue. Thank you, Mr. Moderator.
You're welcome. Any further discussion?
Pam Papineau, Whitcomb Avenue. With regard to Mr. Horgan's suggestion, it seems to me that falls within the purview of the ZBA. So I don't really understand why we would take just that one little piece and say that's subject to a different interpretation or decision by the planning board, when anything else under the bylaws goes before the ZBA. Sounds to me like a ZBA topic, not planning board topic.
Any further discussion? There being none, all those in favor of approving Mr. Horgan's amendment, please say aye. Aye. Opposed? No. The ayes have it. Motion is carried. The amendments on these bylaws only require a majority vote. So the amendment is agreed to. Now the article comes. Now we get back down to the original motion, original amendment to strike out that next line, which I believe, Mr. Rich, you said that now is no longer needed? Okay, so we don't have to read. Okay. So we're going to vote. Hold it. I need Dr. Okay, now we vote on the other amendment as amended. All those in favor, please say aye. Opposed? The ayes have it, the motion is carried. Now we come back to the main motion. Is there any further discussion on the main bylaw change? Actually, every gentleman right there first.
Mr. Moderator, Ernie Gurdon, 142 Sandy Pond Road.
Yes.
Mike, did I hear right when it was said that we have 8.4 percentage to the 10%? Is that 8.4?
That's what Mr. Lucas said, yes.
Could you tell me how long that's been like that? Because we've had a lot of housing being done in Ayer, and I'm very curious as to why this hasn't gone up or has it come down. How has that been in the last, say, 2 years as far as housing?
Mr. Luca.
Mr. Moderator, from my best recollection, Ernie, it's between 8 and 9%. It's as far as affordable housing is concerned, we've had housing being built,
right,
but it hasn't. The percentage of it hasn't risen to the extent where it would be higher than. I think just about 9 or 8.9 has been the highest that I'm aware of.
So how do they get that up there to over 10%? Because it's been like this for quite a while, and we've had the housing.
Well, if you
is it the contractors that have to determine how many housings are going to be affordable?
It all depends. It comes in front of the planning board. They decide what they're going to do with it. The developer does. The only real way to get it higher up there is if you have a development that's all affordable, then that'll bring up past the 10%. But you don't want to do that. The way we're doing it right now, we're doing it at a little bit at a time. Paul, did you have something?
Mr. Archambault?
Yes, Mr. Moderator, I would like, if possible, for our planning consultant, Judy Barrett, to speak to this issue. She has extensive experience in housing in the state of Massachusetts.
Okay.
She's a non-resident, so she would need to...
Actually, no, she is a consultant town area. She's a special town employee. She can speak without needing the 100%.
Okay.
Through you, Mr. Moderator. It's a privilege to be a resident of Ayer for the evening. You don't have in your bylaw right now the kind of provision that allows the town to require developers to provide affordable housing. So the only way it's going to happen here is either out of the goodness of some applicant's heart or a Chapter 40B comprehensive permit. What happens between two census periods, every 10 years we have a census, that resets the clock for the percentage of affordable units in your town. So as the decade goes forward and you're adding more market rate housing but not really adding any affordable units, you don't see the problem until the next census hits and your new total housing count is reported, and now you might go from 8% down to 6%. But people don't realize that. So the whole reason this is in here is to give the town another tool to create affordable housing in addition to the Chapter 40B comprehensive permit.
Are you saying that is in there, in the bylaws now that it's proposed?
It's in the proposed bylaw, yes it is.
It is?
Yes.
That it be required?
That the plan for multifamily and townhouse developments, that the planning board could require some affordable units, yes.
Mm-hmm.
It's in here.
Okay, thank you.
Yep, you're welcome.
Any further discussion? Mr. Gardner? Yes, it is.
Perhaps town council could answer this question. I think there are several communities in Massachusetts with their zoning bylaws that allow smaller lots to count the frontage on two sides to make up the full frontage without it having to have the angle, which is virtually almost a straight line. I mean, it's about 120 degrees as opposed to 180 degrees. So, I mean, was there any consideration given to the planning board when that was being discussed as to allow smaller lots to be utilized? That, I think, would provide an additional tool for so-called affordable housing if you're going to allow development on smaller lots.
Mr. Diskin?
As presented by Mr. Archambault, one of the key elements of this proposed bylaw was for we did not look at dimensional changes. We felt that the history of the town and the size of the lots and whatever the dimensional requirements were now was something that should be left the way it is because it has a history in we felt it was something that was too delicate to change at this point in time. So we did not look at the fact of changing frontage requirements for distances that are on a corner lot. We simply stuck with the traditional the zoning table now that has the distances in it and made no changes there.
All right, so right now the interpretation is that you have to have the mandatory frontage on at least one side of a corner lot. You can't use the two sides if they add up to the total requirement. Is that correct?
That's correct.
All right, so there wasn't any decision.
There was no discussion
made.
because we never looked at
All right.
making any dimensional changes to the existing zoning requirements.
Future study.
Would it be permissible, Mr. Moderator, to ask the town council, what in his opinion would be, say, the majority of the zoning bylaws in the Commonwealth of Mass? Do they require the frontage on one side of a corner lot, or do they allow two sides?
He's looking at me and shaking his head, so I don't think he knows the answer. Oh. It's not relevant to the question.
Well, I think that's up to the moderator to make
Yeah.
the determination.
And I think I'm going to agree with him.
All right. All right, thank you.
Any further discussion? Mr. Horgan.
I'd like to make a motion, Mr. Moderator, to amend Section 9.1.5 B.4 of the proposed air zoning bylaw, inserting the following sentence at the end of Section 9.1.5 B.4. Common driveways and shared driveways shall be no longer than 800 feet unless otherwise approved by the planning board.
Is there a second to the motion?
Hear that again?
Yeah, I didn't hear it.
Okay, Kev, can you repeat that? And she's going to need that one in writing. Okay.
Mr. Moderator,
Mr. Horgan.
common driveways and shared driveways shall be no longer than 800 feet unless otherwise approved by the planning board.
Okay. Is there a second? I'll second that. It's been moved and seconded. Any discussion on the amendment? Mr. Moore.
I'm starting to have a problem here in town meeting. That amendment that Mr. Horgan is doing is absolutely trying to shut our project down. We've been doing there's no secrets in town that we're putting a solar field in that produces green energy versus oil-fired furnaces. We've been going through the permitting process in the town of Ayer for over a year. We have been held up by planning board, which Mr. Diskins is a member of, lack of quorum, postponement, only available for 15 minutes, etc. And that's why it's been dragged on. That parcel of land that we're developing, we have a right, by right, to develop that land by the town bylaws. Selectman's office, planning board, the building inspector, the planning board, the conservation commission, town council have all agreed that we do not have to go for site plan approval. Those neighbors appealed it. There's no secret. Excuse me.
State your point of order. That's true.
I guess I'd have to come up with saying, well, where do you come up with 800 feet? Because that squarely shuts our project down. Now, we went through over a year of permits.
Mr. Moore.
All right, I'm going to make an amendment on the floor then, Mr. Moderator.
Okay?
All right? Do I give it to you in writing?
Yes, you do.
Do I make the motion now or after his is voted on?
Now.
Do I insert the words in section 7.1.a or to site plan approval granted? What the bylaw says, it says shall not apply to structures or uses lawfully in existence or lawfully begun or to a building or a special permit issued. And I want to insert the words or to a site plan approval granted.
Actually, I just spoke to Mark Rich, Town Council, Mr. Moore, and actually that amendment is not germane to the proposed bylaw changes.
Which amendment?
One you just made.
Why is that?
Mr. Rich. Oh, yeah. It's not amendment. It's not germane to Mr. Horgan's amendment. It's germane to the bylaw change, but not to Mr. Horgan's amendment. So we're going to hold off on this, and then we'll do a vote on Mr. Horgan's amendment first, and then come to yours.
Thank you.
Okay, hold it. You can... Okay. Okay, a little confusing up here. I thought when Mr. Rich says out of order, he was talking about Mr. Moore's amendment. He was not. He was talking about Mr. Horgan's amendment. And after talking to him, that amendment is beyond the scope of the proposed changes in bylaws, and it was never brought before the Board of Planning Board, which has to be done before it's brought to town meeting. Now, Mr. Moore, if you'd like to make your motion, you're more welcome to go right ahead.
Amendment to insert the words in section 7.1.A to include the words "or to a site plan approval granted." That would come after the words of "this bylaw shall not apply to structures of usually lawfully in existence or lawfully begun or to a building or special permit issued," and insert the words "or to a site plan approval granted," which is only fair.
Okay. Is there a second? So moved and seconded.
Moderator.
Okay, here we go. Okay. Mr. Rich, he's going to answer the...
Mr. Moderator, through the meeting, I apologize for the complications. Zoning is a complicated area, hence the number of experts, the number of folks who have been required to address it. The concern here is, again, you're bringing a site plan approval process into an area with respect to matters that are not generally subject to site plan, are not subject to site plan approval. And so I think this is an issue under state law, and is really outside the scope of what's being presented to town meeting again.
Okay. So that amendment is also ruled out of order. Mr. Cadigan.
John Cadigan, 203 Autumn Ridge Drive. Would I be correct that Mr. Moore is already protected under the Fifth Amendment to the Constitution, having filed a plan, having it been approved, a process in motion, and given that this will not be approved by the Attorney General for an extended period of time, to impose the 500-foot or any limit on him would
that actually
taking...
Mr. Cadigan, that's already been pulled out of order. That's already ruled out of order. Any further discussion? Mr. Bertha.
Mr. Moderator, this question is for the lawyer. I would like to know why we can't make amendments on the floor.
Mr. Rich.
If I may, Mr. Moderator, you can make amendments on the floor, but only within the scope. Zoning is very different than other questions that come before town meeting.
Okay.
You cannot amend a zoning bylaw in a manner that is more restrictive than what has been presented under the bylaw that's in the warrant that was subject to the planning board hearing. So certain restrictions that are being considered would be more restrictive on land use, and there was no notice of that. The town meeting members were not warned of that. You have a very specific document that you're considering. So if you wanted to broaden rights, you could conceivably do that. You cannot narrow or restrict rights by motion under the zoning process. It's a bit different than other articles that we consider at town meeting.
Okay, thanks.
Mr. Moore.
Correct me if I'm wrong, but I'm going back to my original amendment here. It is broadening and being less restrictive.
It's not consistent with the statute.
Mr. Moderator.
Mr. Rich.
The issue there, though, is statutory construction. I'm not disagreeing with you that you might be adding a protection, but it's not consistent with the provisions of the Zoning Act, Chapter 48.
Okay. Any further discussion? There being none, and this requires a two-thirds vote. All those in favor, please say aye. Aye. Opposed? In the ears of the moderator, it is two-thirds, and therefore it is passed. Article 2, Proposed Air Solar Energy Systems Overlay District Bylaw. To see if the town will vote to adopt the new zoning bylaw, Section 8.5, entitled Solar Energy Systems Overlay District Zoning Bylaw, as available for review on the town website and as on file in the offices of the town clerk and the planning board. Said bylaw regulating the installation, siting, and approval of solar energy systems within the various zoning districts of the town, or to take any action thereon or in relation thereto.
Mr. Moderator.
Mr. Luca.
I move that the town vote to adopt the new zoning bylaw, Section 8.5, entitled Solar Energy Systems Overlay District Zoning Bylaw.
It's been moved and seconded. Mr. Archibald, did you want to do? Oh, Mr. Tillotson, okay. Mr. Tillotson, okay.
Mr. Moderator, the Ayer Planning Board held a public hearing on the proposed Ayer Solar Energy Systems Overlay District bylaw on February 15, 2018. At the conclusion of that public hearing, the Ayer Planning Board voted unanimously to recommend Article 2, proposed Ayer Solar Energy Systems Overlay District bylaw, to the Ayer Town Meeting for approval. Thank you, Mr. Moderator.
Welcome. Mr. Archibald, he has another presentation on this article.
Yes. Thank you very much, Mr. Moderator. Before we get into the fine details of the bylaw, I wanted to clarify a few key terms and concepts that pertain to solar energy use. The first is principal use versus accessory use. Principal use can be thought of as the primary use of a lot, whether it be a home or a solar field or an industrial building, whereas an accessory use would be something that is secondary, such as a shed or swimming pool or that sort of thing. So the way the bylaw is structured, there is a difference between how principal and accessory solar uses are treated, which we will be getting into. The second is between roof-mounted and ground-mounted systems. Roof-mounted, as the name implies, are solar energy systems, including solar hot water that would be placed on a rooftop. Ground-mounted are placed on the ground. And both of these can be at three different scales, as defined by the state guidance document: small, medium, and large scale, which I will be describing in the next slide. Okay, a small-scale solar system would be a solar energy system that occupies 1,750 square feet or less of area, or generates less than 10 kilowatts of energy. A medium-scale solar energy system would be one that is between 1,750 square feet and about 40,000 square feet in size, 40,000 square feet being just shy of 1 acre. And these systems generally generate between 10 and 250 kilowatts of power. A large-scale system occupies 40,000 square feet, roughly an acre or more in land, and generates over 250 kilowatts of power. So there is a two-pronged approach to how these solar energy regulations will work. The first is a zoning bylaw that is the subject of this warrant article. It is administered as an overlay district in the zoning bylaw. It regulates the time, place, and manner of the allowed uses in the various zoning districts. It requires a vote of town meeting. The solar energy regulations, on the other hand, will be administering the fine details of the plan submittal and plan review requirements for the proposed solar energy systems. And these would become part of Ayer's site plan regulations, which requires a vote of the planning board but not of town meeting. I have drafted, based on the state's guidance document, a set of regulations that the planning board is considering right now. And the regulations will address plan submittal requirements, what you need to bring to the planning board to have your plan reviewed, the review procedures, provisions for interdepartmental review where we consult with the building department, the fire department, etc. Design standards including fencing, visual landscape screening, signage, public safety, all those issues. Any provisions for waivers, criteria for planning board review and approval, and provisions for surety or, guarantee that if the developer went out of business or left town and the solar energy system was half finished, there would be a bond or some sort of financial mechanism in place to allow the town to either remove the facility or to bring it up to standard so that it can operate. One important note is that in the state law, if a town does not address solar energy in its zoning bylaw, it is basically presumed that all scales of solar energy can occur in any zoning district. Okay, this is the key part of the solar energy bylaw, which is the table of permitted uses. I did find my laser pointer, and Mr. Moderator is not in my line of... On the row on the top of the zoning districts, you have the A1 residential district, which is the more rural part of town and the north central part of town. That requires a 40,000 square foot lot area. The A2 district is to the west of that, which requires a 12,000 square foot lot area. General residence is the area that is surrounding the downtown, which is the more dense, historic neighborhoods. Downtown business, the mixed-use district that was just created in the previous bylaw. General business, which is the more highway-oriented zoning district. Light industrial, and the healthcare services, which is the Neshoba Valley Medical Center. And you will see that in the column on the left, you have small scale, ground mounted, medium scale, large scale, and that applies for solar as a principal use. Solar as an accessory use also applies to all these districts at the same scales. One important takeaway is that roof-mounted systems, if you would like to place solar energy on your roof, whether you be a residence or a 50,000 square foot industrial building, that is allowed by right, which means that you just need to go to the building commissioner or the building inspector to obtain a permit for the solar energy system on your roof. So that is allowed everywhere. The key feature is that large-scale systems are being prohibited in this bylaw from the residential zoning districts and also downtown business because there's not really much room to place an acre solar array field, or the mixed-use district, which also has smaller lot sizes. The large-scale systems are allowed by special permit with the planning board in the general business district and with site plan review in the light industrial and in the industrial district and special permit in the healthcare services. Special permit is a process where an applicant goes to the planning board and they have to meet certain criteria such as setbacks and they have to be able to fit into the neighborhood. And it is possible for the planning board to deny a special permit if they do not meet those criteria. Whereas with site plan review, the SI, it is generally presumed that the use is allowed, though the planning board would like to have a little bit more oversight in terms of how that solar energy will be developed on the site. And where you see a little bit of a difference between the accessory uses and the principal uses for solar, that is due to the fact that if you have an accessory use, you have a principal use, which could be a residence or a building, and that person or business is there to make sure that the system is operating correctly. It's, that person or business is there to consult with if something isn't going right. So that is why there are small differences between the accessory uses and the principal uses in terms of solar. So again, in developing this bylaw, I used a state guidance document from the Executive Office of Energy and Environmental Affairs. And it did talk about the siting of large-scale solar systems. And basically, the Commonwealth of Massachusetts discourages replacing mature forest or agricultural land, natural habitats, with large-scale solar arrays because you'd have to take the trees down. So, even though solar is green energy technically, by removing the trees, you're actually taking out a carbon sink that would be absorbing carbon dioxide. You're also destroying wildlife habitat and potentially causing stormwater problems. So that is the reason why large-scale solar energy is being discouraged from what's called a green site, or a site that is vegetated. Also, locating large-scale solar projects in or near residential areas can cause conflicts. And when you look at a zoning map of Ayer, or a map of Ayer, it is apparent that there are many underutilized and previously disturbed areas within the general business and industrial districts which would be very suitable for large-scale and medium-scale solar projects. There are large parking lots in Ayer's industrial districts, many of which are half empty, would be perfect for that. In many other states, you see large-scale solar arrays being used as shelter or shade for car parking. So there are many creative ways to locate large-scale solar systems in a town without cutting down forest. And that is what I just mentioned. And here is the zoning map of the town. Basically, there was a little mixed-use district that we looked at. This is the A1 residential district, which is predominantly forest, and a lot of ledge and wetlands are up here. So that's an area that, we would like to target for more preservation. This is the A2 residential district. This is the general business in the pinkish color, both along Park Street and along West Main Street as you go into Devons and around the Rotary. We have a large area of industrially zoned land here on the eastern part of town, much of which is suitable for solar energy as well. So we feel that there are ample opportunities to site the larger solar scale systems in the town of Ayer. And that is why we propose the table of uses such as we did. And Mr. Moderator, that is my presentation.
Thank you. Okay, the article's been moved and seconded. Is there any discussion? Ms. Bedurtha.
Mr. Moderator, it looks all really good up there, but you know what? What happened over at Oak Ridge Drive doesn't fly. Whoever doesn't know about that one. Anyway, this is questions for the lawyer again, if you don't mind.
See, your question, Elizabeth. You can't answer until you ask it.
Oh, okay. What does right through a building permit mean?
What? Could you place that in context? I mean,
Yeah, it's right in the article itself, like the fourth line down.
Essentially, she's asking a by right use, what that means.
Through you, Mr. Moderator, are you asking what does a by right use entail?
Yeah, what does that mean?
It's a use that's allowed by right, that no permit is required, that it would be allowed by right under the bylaw.
By right, you're meaning, do you mean if I own that land, I can do what I want with it? Is that what you're saying? By right?
Can go right to a building.
You'd still obviously be required to get whatever permits, a building permit to construct a structure. It's a land use that's allowed by right. It's not prohibited.
Okay. Okay. Can a builder use or go through someone else's property for this solar stuff? Can they do that? Even if they don't own the property?
that is not germane to the solar bylaw amendment. That would that'd be done under the regular zoning bylaws, which was already discussed last article. It's not germane to this article,
Okay.
Elizabeth.
All right. I'm just trying to follow along. And what happens with variances on this? Will the planning board give variances? That kind of worries me.
Mr. Moderator, to the question, it's the Zoning Board of Appeals that would issue a variance. And yes, there is a provision in the air zoning bylaw to allow use variances, which is sort of a check and balance on the planning board's power, you might say. We did not remove that. There are some towns in the Commonwealth that do not allow use variances, though the town of Ayer does. But we did not want to make such a whole-scale change to the zoning bylaw by prohibiting use variances. So the ZBA still has the power to issue a use variance for prohibited uses, though technically it should be very difficult to get a variance. There are many criteria that you have to meet.
Not in this town. Not in this town. The other question I had, Mr. Moderator, through you, the pink areas that were defined where you could put solar, do different people own those properties in town, or are they town-owned?
No, most of them are privately owned, or maybe some of them may be public land.
Okay.
That's existing use already. That's been the bylaw.
Okay. Okay, I won't vote for this. I think it's a mistake. Thank you.
Any further discussion? Hold it.
Oh, sorry.
James Beyond 16 Pond. I would like to have an example, 2 examples, if it could be placed there. We're building a new train station. Just like that picture, could it be used for there? And say something like the Air Rotary. Can you put solar around that?
Mr. Archibald.
Mr. Moderator, to the question, I believe the Air Rotary is in the general business district, so technically it should be possible, though you'd have to look. I mean, the question is, it's really hard to answer in a general sense of whether you can do something on a particular site, though it
It's
does.
also state highway. It's state land.
It's state land, so yeah, if anything controlled by the state is a whole different matter. Again, that would be difficult for me to answer, though, in general, the area around the railroad tracks could be suitable from a land use perspective. It would depend on the ownership and what sort of restrictions apply for the railroad right-of-way and that. Yes.
Could solar be put on top of the train station itself?
Technically, yes, I believe.
Yeah, his question was, could solar be put on the roof of the train station? And his answer is yes. Jim, I think you're a little bit too specific. Okay.
Jeff Mays, 72 Pleasant. Can Can you better explain the size, particularly getting more on the larger scale? Because an acre of solar panels is drastically different than solar panels on an acre. Are you talking an acre worth of solar panels that are all sitting right next to each other? Or are we talking an acre of land that has solar panels on them and there's only 12 solar panels on an acre?
Mr. Archambault.
Yes, Ms. Moderator. The size is defined by essentially the footprint as you would, take the vertical line from the solar panel array area and just go down to the ground. So the solar array, could be, in most cases, would be smaller than the entire lot that is occupying. So it's not the size of the entire tract on which the solar is being sited. It's the size of the array in square footage.
So they could, in theory, jam absolutely have no vegetation, no anything. Not that it's practical from an engineering standpoint, but they could do an acre worth of solar panels and there's absolutely zero green in between, underneath, around. I'm just saying in theory, because I know practicality it probably wouldn't happen, but that's what you were definitely saying. It is 100% the actual panel we're talking.
Mr. Moderator,
Mr. Archambault.
The solar energy regulations that we're developing do have requirements for landscaping and keeping vegetation as much as possible, both underneath and surrounding the area. And that is something we're working on. We'd encourage you to come to the planning board meetings, which will be taking place over the next few months, where we finalize the regulations on the solar energy systems.
Any further discussion?
Mr. Moderator, Ernie Gretton, Sandy Pond Road. Would this, if this passes tonight, would this have any effect whatsoever on anything that might be in the process now of being done as far as residential?
Mr. Archibald.
Uses that have been approved in the past would be pre-existing non-conforming if they're not within the zoning district that they're allowed in. So, again, for most residential areas, you could put a rooftop solar, and in most cases you can put a small scale ground-mounted solar array in a residential area in most of those.
Right, but if this was in the making now, say if somebody had this in the making already and this passes tonight, would that have any effect on what they would have to do? Would it change anything?
I don't believe so, unless...
Because the people that do have this would want to know for sure.
If they had not obtained any permitting at all, then it may affect them. But if they do have a permit in hand and they just haven't constructed it,
Is permitting required right now as is if somebody wants to have it put on their roof or on their lawn? Is the permitting required for that, or can they bypass that?
Mr. Moderator, to the question, a building permit would be required right now under our existing zoning?
Yeah.
Just a building permit.
The zoning enforcement officer is nodding his head yes.
Yes.
Yes, what? What did he say?
That you need a permit now.
You do need a permit.
You do need
now.
a permit, yes.
So anybody building one now has to have a permit, or they're not in compliance. Is that right? Even if it was started 6 months ago or a year ago, but not finished. Is that true?
Mr. Schultz.
That's true? Okay, thank you.
Ms. Bedertha.
Mr. Moderator, I have one more question. If someone wanted to put solar behind, let's say, the hospital, how can we be assured that the vegetation won't be destroyed there and it won't be close to the rail trail?
I think Mr. Archambault already answered that. They're working on the planning board is going to be working on regulations the next several months to ensure that vegetation stays where it's supposed to be.
And what about the rail trail?
Well, Mr. Moderator, to the question, any large or medium scale solar use being proposed in the healthcare services district by the hospital would either require a site plan review at the very least or a special permit through the planning board. and looking at the vegetation and screening and compatibility with surrounding land uses would be a key factor in the planning board's decision. They do, any large-scale solar use in that district would require a higher level of review than, say, in the industrial district.
Okay. Moderator? Mr. Moderator?
Where?
Over here.
Oh, yeah, okay. Ms. Kennedy, okay.
Thank you. Sue Kennedy, Nashua Street. I just wanted to clarify, because there's been a lot of specific questions. Right now, solar is allowed under the state law by right, and some of the problems we've had is we can't regulate it. This bylaw gives us an outline where we are now allowed to make regulations and specify landscaping and change regulations from time to time as the situation occurs. But without this bylaw, we're not allowed to do that.
Thank you. Any further discussion? There being none, all those in favor, please say aye. Aye. Opposed? It's unanimous, therefore it is a 2/3 vote, and it is passed. And Kevin, before we leave, don't get used to me calling you Mr. Horgan. Do I hear a motion? We have a motion and it's seconded. All those in favor of adjournment, please say aye. Aye. Opposed? Didn't think so. We're adjourned.